Friends, welcome to Law NGK. So friends, on this channel we discuss the contents of law and previous year papers of judicial services and other legal exams. So friends, in today's video we are going to discuss the pre-exam paper of TAMILNADU Judicial Services 2019. So friends, if you are new on this channel, I would like to recommend कि आप जो है इस चैनल को जल्दी से सब्सक्राइब कर लीजिए because it will be very beneficial for you in your preparation for judiciary and other legal exams. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. And if you like this video, just click the like button over there and appreciate this with your friends so that they can come to know about this channel as well. And अगर आपको हमारे efforts अच्छे लगे हों तो in addition to like and subscribe, kindly give us a super thanks. You can see the paper comes like this. So this is the series number, the first page in Tamil. I have downloaded this paper from the High Court website. You can just go over there on the Madras High Court website and you can download it from there. Over there they have mentioned the answer key copy, means whatever they have marked here is the answer key. Let's move to the questions. So what the question number 1 says. Question number 1 says, which of the following is true in respect to right to be forgotten in Indian context? So statement number 1 is the Karnataka High Court in a judgment recently has approved the right to be forgotten in Indian context. Yes, this is correct. The case was Shri Vasutham versus Registrar General. Okay, decided in 2016-17. So you can just find it over there. Next is it allows offender to object the publication of information regarding the crime and conviction. It is correct. The origin of this right can be tracked back to the French jurisprudence on the right of oblivion. Yes, it is correct. Next is the right to be forgotten can be inferred from the provision of IT Act. No, this is incorrect. So 1, 2, 3 are correct. B is the answer. The question paper comes in 2 languages, Tamil and English. This is in Tamil. You can just read it over here if you want. Next is 2. By considering the shortage of labor for agricultural purpose, the state government enacted a law to prohibit engagement of agricultural labor in the manufacture of BD. Choose the appropriate response on the constitutional validity of the law. Now you have to judge the constitutional validity of this law which prohibits the labor to go to the BD manufacturing. A is since labor would not be available for the agriculture, but there can be shortage of the food and wastage of the crops. This is correct, but this is not as per the constitution. B is the object sought to be achieved is to keep the sufficient labor supply for agricultural purpose, which would have been easily achieved by restraining employment of agricultural labor in BD manufacturing during the agricultural season only. So see, till here they are mentioning the same thing which I have written here. Okay, but they have used the word only. They are saying that only for the agricultural season we are restricting the labor supply to the BD manufacturing, not for the whole year. So this is a reasonable restriction. Okay, na? Absolute restriction amounts to withdrawal of the right, hence the law is unconstitutional. The restriction should not be absolute. B is the answer. Next is 3. The pardoning power given by the president under Article 72 of the Constitution can be exercised only after the conviction, because this is pardoning power and the pardon can be granted only after a conviction. So after trial of the conviction and award of the sentence. It is correct. A is the answer. During or at before, and during and before is not possible. So these 3 are incorrect. Next is 4. Identify the ground that is not available to proclaim emergency under 352 of Constitution. So armed rebellion is there, external aggression is there, war is there. Internal disturbance was earlier there, but it has been deleted by 44th Amendment, and instead of this, armed rebellion has been substituted. So this is not there, not available. D is the answer. Next is 5. Which one of the following statements about the meaning of eminent domain under the Constitution of India is correct? Sovereign power of the state to acquire private property of an individual for public purpose after paying compensation. Yeah, this is correct. Eminent domain hai. This is eminent domain. Power of state to arrest an individual. No. Requisition. No. So only 1 is correct. C is the answer. Next is 6. In a case of guarantee, liability of the surety is primary, secondary, or coextensive. Coextensive with that of principal debtor. C is the answer. And where it is mentioned? It is mentioned in section 128 Contract Act. All right. Next is 7. Sasi and Co., a building contractor, entered into an agreement with Sky Heights Housing Association to furnish a block of 30 flats. This contract was subject to liquidated damages clause if they did not complete the contract on time. Sasi and Co. engaged Lokesh to do carpentry work for an agreed price of 50,000. After 6 months of commencing the work, Lokesh realized that he had priced the job too low and would be unable to complete originally agreed price. Sasi and Co. agreed to make additional payment of 1575 per flat. Now you see there is an alteration in the agreement. Why I'm saying alteration, why not novation? Because he is not doing some else work. So the main nature of the contract has not been changed, only the price, additional price is there. So this is an addition in way of alteration. Lokesh worked for a further period of 6 weeks but only received additional amount of rupees 1000. He then ran out of the money and refused to continue unless payment was made. Sasi and Co. engaged another carpenter to complete the work and refused to pay the Lokesh for further sums. So this is wrong. They should pay him. Answer options are: the agreement to pay extra was unenforceable as there was no consideration for the subsequent agreement. There is no requirement that because that is only an alteration, not an new contract. Then B is consideration was provided by the location in form of conferring a benefit on the Sasi and Co. by helping them to avoid penalty clause. Yes, it is correct. Therefore, Sasi and Co. was liable to make extra payment promised. Yes, it is correct. Next, C है फिर the consideration provided by the location as avoid penalty clause was not main object of contract. Therefore, अब now here they are denying not, then they are saying it is the reason. No, it is not correct. Then liable to pay consider as they have committed a breach of contract by employing another carpenter. No, this is wrong. B is the answer. Next is 8. What is continuing guarantee? Guarantee which extend to series of transactions. C is the answer, and where it is mentioned in section 129 of Contract Act. Next is 9. A wanted to sell his house to B and made an offer by email to sell his house at 65 lakhs. On the same day, without knowledge of A's email, B sent an email to A informing him that he would like to buy the house for 65 lakh. Identify the correct statement. The contract is valid as both offer and acceptance has been no. Both parties have agreed upon no. Invalid as there is no acceptance. C is the answer. कैसे? How? Because this is a cross offer and nobody has given any acceptance to each other. C is the answer. Next is 10. Statement A. A surety discharge from his liability under a contract guarantee is the creditor does or omit to do something that results in impairment of remedy available to the guarantor against the principal. This is correct. Statement B is the guarantor is invested with all the rights which the creditor had against the principal debtor after due payment and performance by him on the behalf of principal debtor on his default. This is also correct. Both are correct, and B is the reason for statement A. C is the answer. Next is 11. Which of the following is not true in respect of contract of pledge? Pawnee cannot retain the goods for recovering extraordinary expenses. This is correct. Then B. A pawnee can exercise the right of lien and right to sue simultaneously. This is also correct. Pawnee may sell the goods on default by the pawner without giving notice. No, this is wrong. Notice is important. This is not true. C is the answer. Pawnee has security interest which enforce even against the state. Yes. Yes, this is also correct. So C is the answer. C is not true. And this is mentioned in section 176 of Contract Act that a reasonable notice of sale shall be given to the pawner. Axis 12. If the promisee accepts an anticipatory breach committed by the promiser, then he need not to perform the part of the contract, but he can claim. देखिए need not. ठीक है, must perform ये तो हो गया wrong. So these three are the options. He can claim damages for the promiser only after date of performance. No. Without waiting till the date of performance. C is the answer. Section is 39. Can you tell any case on anticipatory breach? Avery versus Bowden and Hochester versus De La Tour. Have you heard of these cases? If not, then just look at these cases. Next is 13. Can the legal representative of a deceased person negotiate a negotiable instrument capable to order by delivery only which was endorsed by the deceased but not delivered by him. The legal representative can negotiate only या फिर the LR has to re-endorse it and deliver the instrument to effect a valid transfer. Re-endorse करना पड़ेगा. Re-endorsement is necessary. Without re-endorsement, it will be null and void. So B is the answer, and where it is mentioned in section 57 of the Negotiable Instrument Act. Exercise 14. Anmol issues a check for rupees 1000 to an NGO as donation. The check was returned unpaid with reasons fund insufficient. The NGO can file a criminal complaint? No, because it was not due to them. There was no debt. No criminal complaint can be filed under 138 as a check was not issued for any discharge of any legally enforceable debt. B is the answer. Exercise 15. Contribution to the mortgage debt means ratable payment of debts to different properties of distinct and separate rights. D is the answer. And where this is mentioned, it is mentioned in section 82 of Transfer of Property Act. Exercise 16. Litigation commences from a date of presentation of plaint before the court. B is the answer. And where it is mentioned in order 4, where it is in rule 1, it is mentioned that every suit shall be instituted by presenting a plaint in duplicate to the court. When you present the plaint, that means suit has been instituted and litigation commences. So B is the answer. Exercise 17. A gives a lakh of rupees to B, reserving to himself with B's accent that right to take at pleasure rupees 10,000 out of 1 lakh. Examine legality of this gift. Gift hold goods as to rupees 90,000 but void as to 10,000. D is the answer. Where it is mentioned in section 126 of Transfer of Property Act. And this is illustration B of that section. Next is 18. In which of the following cases the doctrine of lis pendens will not apply? Suit decide ex parte, yes. Finally, suits brought, yes. During pendency petition, yes. A suit results in consent or compromise decree, that over there lis pendens will not apply. A is the answer. And where doctrinal lis pendens and this doctrine is provided in which provision of TPA? Section 52 of TPA. Next is 19. Statement 1 is gift deed of immovable property value of less than 100 requires compulsory attestation by witnesses and registration. Yes, this is correct. And where it is mentioned in section 123. Next is statement 2. Necessity for examining the attesting witness arises only when the gift deed is specifically denied. It is correct. Irrespective of the fact whether the gift deed is denied or not, examining the attesting witness is condition precedent. No, that time it is not required. So 1 and 2 are correct. B is the answer. Next is 20. Ramesh, an advocate, takes up a private employment. Ram, his erstwhile client, approaches him for legal advice and the same is given by Ramesh. Later in a criminal proceeding, Ramesh was called upon to disclose his communication with Ram. Ramesh also disclosed the same in the court. Now we have to tell whether this communication was privileged or not. So see, in all options, it is mentioned section 122. And do you know what is section 122 of Evidence Act? It talks about marital communications. Okay, first of all. So he is an advocate and communication with his client. So this is a communication with legal advisor as per section 129 and it can be a professional communication as per 126. Alright. So whether this would be privileged under 122? No, it is not privileged under 122 because this is a wrong option. Section is wrong. Alright, so this is a trick question. Now somebody would be thinking that 122 is for professional communication, this is privileged. Okay, so it's a trick question. B is the answer. Next is 21. Which of the following is not a substantive piece of evidence? Expert, inquest, TIP, they are all are not substantive piece. D is the answer, all of the above. Next is 22. Which of the following is false about a private document? All the documents other than public document are private document. It is true. A private document is prepared by a person for his private interest under private right, yes. Private document is in the custody of person to whom it belongs and is not available for general inspection to public, yes, it is correct. Then, as a general rule, the court is bound to presume the genuineness of private document from a duly certified secondary copy. No, it is incorrect. D is the answer. This can be for the public document, but not for the private document. D is the answer. And where public document is mentioned 74, private document 75 of Evidence Act. Next 23. Whom the following are police officers in the meaning of section 25 of Indian Evidence Act? A forest ranger, custom officer, central excise officer? No, they are not. D is the answer. None of the above. Next 24. Which among the following statement is not true? They are asking not true. An admission by a party in a plaint signed and verified by him may be used as evidence against him in other suits. The person making an admission in a pleading cannot take advantage of it. An admission made by a person in a proceeding to which another was not party, such admission is not admissible against the other in a subsequent suit in which both are co-defendants. This is also true. तीनों ठीक हैं ये, none of the above रहेगा इसका आंसर. D is the answer, none of the above. SC 25. ABC meet at coffee shop to discuss the enmity they had against D. A in particular leads the discussion by venting out his grievance against D, to which B and C nodded in agreement. They agreed to murder D by mixing poison in D's coffee. The trio meet F and inform him the plan, who willingly procured the poison for them. F is guilty for the offense of abetment by intentional aiding. D is the answer. SC 26. X, a doctor, informs the patient Y that he has cancer which is in last stage. X requests Y to arrange family affairs as he cannot survive more than a couple of weeks. Y dies because of shock on hearing this. X is guilty or not guilty? Not guilty of any offense. B is the answer, because he gave the communication in good faith. Section 93 would apply over here. 93 of IPC. Next 27. A servant collected money from the debtor of his master as authorized by him. The servant retained the money because it was due to him as wages. He commits criminal breach of trust. See, the answer was given by the answer key was D. Alright, but I'm not satisfied with that, because he collected the money from the debtor because he was authorized by his master. Okay, he did not find that money. Criminal misappropriation is somewhere where the person finds the money and for which he was not authorized to take. When somebody is authorized to take, then he is entrusted with that thing. So where the entrustment is there, it would be criminal breach of trust. Even his money was due, it was not the legal way to get his money as wages. So he has committed criminal breach of trust. It is mentioned in section 405, and you can see illustration E of section 405 IPC. Next is 28. X has consensual sexual relation with Z's wife. She gives to X a valuable property which X knows belong to her husband Z. She has no authority from Z to give. X takes the property which are the following. He has done theft. C is the answer. And this is illustration O to section 378. Next is 29. Common intention implies similar planning, pre-arranged planning, presence of common knowledge, common design for common object. The common object है तो that is would be common object only. The pre-arranged planning. B is the answer. Section 34 mentioned about common intention IPC में. Next 30. Which of the following is true as regards section 410? Conviction of principal offender is prerequisite to the conviction of the receiver of stolen property. No, it is an independent offense. Next is where the property is stolen in a foreign territory brought to Indian territory. He cannot be convicted for theft. He can be. This is also wrong. Then possession of property transferred by theft, robbery alone doesn't as stolen property. However, transfer CMP a trust, that is also stolen property. This is also wrong. So all are wrong. All are incorrect. C is the answer. Next is 31. In a petition to set aside ex parte decree, the court allowed the petition subject to payment of cost within 7 days from the order. Cost was not paid in time. The petition was dismissed. After a period of 30 days, the petitioner filed an application seeking time to extend the payment of cost, which the following statement is correct. The petition cannot be entertained if it can be entertained only along with application in section 5. A period of 30 days provided in section 148 CPC in mandatory, hence petition filed after 30 days is not maintainable. It can be entertained along with if he shows any sufficient cause, because without sufficient cause, if he is doing that, then it would be arbitrary. But it is not mentioned over here. He is asking for the enlargement of time after dismissal. Okay, so it can be entertained but subject to sufficient cause, which is not mentioned here. It should have been mentioned. B is the answer. And where is the provision for setting aside ex parte decree? Order 9, Rule 13. Next, 32. Due to Commercial Court Act, Commercial Division and Commercial Appellate Division of High Court Amendment 2018, specified value in relation to commercial dispute reduced, substituted from 1 crore to 3 lakh rupees. C is the answer. Next, 33. In a suit for partition, the plaintiff claims 1/3 of share from defendant 1 and 2. Which of the following is correct? Defendant can make a counterclaim in a partition suit. They can make counterclaim against another defendant. Making counterclaim can file application to implead parties in the suit. फिर a plaintiff being dominus litis can alone maintain a petition to the implead parties. No. So 1 is correct and 3 is correct. B is the answer. Next, 34. A suit or decree ex parte by the subcourt Tripattur. Okay, this is some place. The subject matter of the suit now falls within title jurisdiction of subcourt Banyampadi. After its constitution, the defendant files a petition under Order 9, Rule 13 of CPC in subcourt Banyampadi, which of the following provision confers jurisdiction on Banyampadi to entertain the application? Section 150. What is Section 150? Transfer of business. The court to which business is so transferred shall have the power and shall perform the same duties as those respectively conferred and imposed by this code. Alright, C would be the answer. Next, 35. A and B are brothers. B resides in a joint family property. A files a suit for partition against B. Which of the following is correct? A can claim mean profit on the date of suit. No, he cannot claim because they are residing in the same place as joint family. He cannot claim mean profits. C is the answer. Next, 36. When the accused is agreed by the report of clinical psychologist as to his unsoundness of mind, he may prefer an appeal to medical board. D is the answer. This is a repeated question. And where it is mentioned? It is mentioned in section 329, subsection 1A proviso of CRPC. You can see that over there. Next, 37. The Supreme Court clarified that in case there is a connectivity problem due to geographical location or there is some other unavoidable difficulty, the time for uploading a file can be extended up to 72 hours. B is the answer. So you should mention the case in the comment section. Kindly write it over there. Just go in comment section and mention the case. Next, 30. A statutory bail is granted to an accused under section 167. Which among the following is correct? The prosecution can seek cancellation of bail under 437 only after filing the final report. No, it is wrong. The court has power to cancel bail only when it is granted under 437. Yes, it is correct. The question of cancellation of bail will not arise when the bail is granted under section 167. No, it can be cancelled on different ground, but not on ground that the final report has been filed. This is incorrect. 2 is correct. 2 alone is correct. See, there are two options now. Statement 1, 2 are incorrect and statement 2 alone is correct. So both options are correct. B and D both are the answers. Next, 39. 4 accused named in an FIR charge sheet was filed against 3 accused only, and the committal magistrate, after due notice to the de facto complainant, took the charge sheet on the file against 3 accused and committed the case to the Court of Sessions. Session Court took the case on the file against all the 4 accused. Now what can happen? Session Court has no power to take cognizance under section 193. This is wrong. Dharampal versus State of Haryana. Hardeep Singh versus State of Punjab, very celebrated landmark judgments. You can see that. Session court can take notice of fourth accused under section 319 only, or not only, 193 as well. Session court should send the fourth case back to the judicial magistrate. No. Shall direct the investigating officer to file supplementary. No. No need for that. So all are incorrect. B is the answer. The second statement was partially correct, but it can change by the word only. If only is not there, then the second statement is correct. Next is 40. In which of the following situation sanction is necessary for prosecution? A subordinate officer files a private complaint against a superior for an offence under section 354A. No, then sanction is not required. A police officer files a private complaint against a superior for an offence under 376. Not required. Government doctor is accused of negligently performing a surgery. Then require. SP jail does not release accused even after bail bond is produced. Accused files a private complaint 342. Then require. So in 3-4 it is require, 1-2 not required. So B is the answer. Next question number 41. Illustration 1 is offences under section 294B and 324. 24B is obscene act, singing and using vulgar language in public, and 324 is grievous hurt with dangerous weapons. Took place on 1/1/16. Complainant filed a complaint in respect to the said offences before the magistrate, and the same was referred to the police under section 156(3). The police filed a final report on. Yes, all right. Next 2 is offences under the same took place on 1/1/6. Complainant filed immediately after the occurrence before the police on the same day. Means FIR has been filed. Police filed the final report on 10/10/2019. So they are asking in which case cognizance can be taken. In both cases. What type of question is that? D is the answer. Next is 42. To assess the competence of 2.5-year-old child victim of a rape before recording her statement at section 164, which among the following question would be appropriate to test the child's capacity to understand and repose? What does it mean to tell the truth and lie? Why this philosophical question? No, it is not required. Difference between truth and lie? No. Next is, if I tell your mom that you just yelled at me, would that be true or a lie? Yes, it is correct. It can be asked. If you tell your mom that I hit you, would that be truth or a lie? It's correct. So 3 and 4 can be asked. C is the answer. Next is 43. Why a famous Hollywood celebrity has won huge amount of damages for defamation against a well-known newspaper? When questioned by reporters on the impact of awarding such huge damages on the freedom of speech and expression, whether such huge damages justify the injury and compensation, why replied that damages should not only be seen as compensation economic loss, but as an example to the other that reputation of a person is invaluable and should not be tampered with. This kind of damage being referred by why are known as exemplary damages. Means damages which set an example for the general public that nobody should do that again. B is the answer. Let's see 44. One night Ravi and Keshav were having heated argument in Ravi's office. Keshav left with angrily slamming the office door violently behind him. The force of Keshav's action caused the door lock to jam and Ravi unable to open the door, leaving his office until locksmith was able to come the next day. Ravi sued wrongful confinement. No, it is not wrongful confinement. It is provided in section 340. Because it was not intentional. Keshav had no intention to confine him wrongfully. So Ravi was in office, hence it was not. Keshav did not intend to jam the lock, hence it would not be wrongful confinement. D is the answer. Next is 45. In which of the following cases Supreme Court directed the compulsory registration of all marriages in India? Seema versus Ashwani Kumar. A is the answer. Section 8 of Hindu Marriage Act provides the provision. Next is 46. The total forest cover in our country is far less than the ideal minimum 1/3 of the total land. Therefore, Parliament by 42nd Amendment of the Constitution has added 2 more articles to ensure improvement of environment and impose duty on every citizen. These are 48A and 51A. This is DPSP and this is fundamental duty. B is the answer. Next 47. The law commission of India in its 259th report suggested including a new fundamental right in the constitution and identify it. That is right to childhood care. A is the answer. Now it's a reasoning question. Question number 48. When the above is folded to form a cube, which one of the following can be produced? So answer would be B. Next 49. Identify the missing number from the suggested answer. This is series 1236-18. So if you do that, 1 into 2 is equal to 2. 2 into 3 upon 2 means 1.5 is equal to 3. 3 into 2, 6. Then again 6 into 1.5 is 9. Then 9 into 2 is 18. So this is the sequence according to my reasoning. If you have different, just comment in the comment section. Answer would be 9. Next is 50. Which one of the following statement is not correct? Under Article 16 of Constitution, the guarantee against discrimination is limited to employment and appointment under this state. Yes, it is correct. Article 16 of Constitution deals with all cases of discrimination which do not fall under 16. Yes, it is correct. Article 16 of Constitution embodies the particular application of general rule of equality laid down in Article 14 with special reference to appointment and employment under the state. This is correct. D है Article 16 of Constitution does not guarantee equality of opportunity in matters of appointment. Wrong है, guarantees. D is the answer, not correct. Next is 51. Article 14 of Constitution permits classification but prohibits class legislation. B is the answer. Next is 52. The admission rules of an engineering college provides that no capitation fee shall be charged from residents of XYZ state, but non-residents shall be required to pay capitation fee. So now they are asking whether it is a reasonable classification. See, Article 15 does not discriminate on the basis of place of residence. Otherwise, religion, race, caste, sex, place of birth, or any of them has been mentioned. This is correct. See, sometimes the paper setter does some mistakes in the question. They try to trick the candidates, but in just thinking that by his act that he is tricking, that they are doing some mistakes. Now you see the statement A is totally correct. And now here asking answer in reference to Article 15 of the Constitution. They have not asked any question over here. Can you see any question? But they are asking the students to assume that this is the question. But this is not the question. This is only a statement. And this statement A is also correct. And you can see next, Article 15(1) prohibits discrimination on the basis of place of birth, which impliedly includes place of residence. No, it is wrong. Article 15(1) prohibits discrimination between citizens on the ground only on this, and the provision suffers from causes amicus and place of residence is inadvertently omitted. No, this is wrong. Article 15 does not prohibit discrimination based on the place of residence. This is correct. This is also correct. But as per the question, if they have said that this is the question, they ask any query on that thing, that D could be the answer. So in making the question difficult, they just take out the nature of the question so that it becomes very difficult to understand. And then later on they will not listen that this is the answer, this is wrong question. Next 53, statement 1 is Article 22 Constitution provides right of the accused to safeguard himself from misuse of power by administration. This is correct. Article 22 Constitution provides right to the non-citizens only. No, this is for citizens. 35 Amendment of the Constitution has introduced safeguard to prevent misuse of power, preventive detention. No, it is wrong. So 1 is correct and 2 and 3 are incorrect. D is the answer. Next 54, which of the following statement with respect to right to know are correct? Right to know the affairs of the government can be traced under Article 19. Yes, it is correct. Dinesh Trivedi vs. Union of India, it was held that the citizens have absolute right to know about the affairs of the government. No, it was said that they do not have. The citizens have no absolute right to know. They only have the right to know whichever the information is good for public. So only 1 is the correct, and so A is the answer, 1 only. Next 55, consider the following statement. High Court has jurisdiction to punish itself for its contempt. It means this is the High Court and they are punishing itself. No. So as I said, the paper setter should look at the things whatever they are putting in the question. Tender advice on the legal question refer to it. No, they do not have any advisory jurisdiction. Issue certain rates for the enforcement of fundamental right. Yeah, this is correct. So 4 is correct, but only 4 is not in option. So 1 and 4 is there, when 2 and 3 are incorrect. So we cannot take this one option. So A would be the answer, but they should have correct this one itself. Next 56. In case sub-agent lawfully appointed, which of the following is correct? As regard third party, sub-agent can neither bind principal nor sub-agent binds principal as an original agent can bind. C is the answer. Section is 192 of Contract Act. Next 57. Which of the following statement is not correct? When the acceptance is required by post but the same is made by telephone and email, it is valid contract, because it can reach the proposer before the post, so it can be valid. B, if the deviation from the prescribed manner is to disadvantage of the offerer, he is entitled to treat the acceptance as invalid. It is correct. If the offerer wants the acceptance to sent by wagon but the same is sent by post, the letter reaches after the arrival of the wagon, the offerer is entitled to treat the acceptance as invalid. It is correct. This is the case. So you can mention the name of the case in the comment section. I will mention it later on if nobody answers in a week. And D is the communication acceptance is complete acts against the proposer as soon as the acceptor puts the post in the transmission. So this is wrong when it comes to the knowledge. So D is the answer, where it is mentioned in section 4 of Contract Act. Next is 58. The juristic concept of the contract consists of agreement and obligation. D is the answer. This is a repeat question. I have seen this in Bihar judiciary papers. You can see that. Next 59. The latest theory of contract is theory of enforceability. B is the answer. Next 60. To sell a thing by a finder under section 169 of Indian Contract Act, when the owner refuses to pay the lawful charges upon demand, what is the lawful charge of the finder? That is 2/3 of this value. It is mentioned in subsection 2 of 169. D is the answer. Next 61. A took his wife B to England for vacation. Due to some business emergency, A had to go back to his place of work immediately. While leaving B in England due to her ill health, A promised to pay £300 per week as maintenance during her stay in England but failed to pay. If A is sued by B, then whether A is liable? No, A is not liable. Why? Because there is no intention to enter into a contract with his wife. B is the answer. And this is a famous case. I will write the initial B versus B. You can just comment in the comment section the name of the case. Next 62. Now you have to match remoteness of damages, that is Hagdale versus Baxendale, liability for fraud, Derry versus Peak, concept of unjust enrichment, Moses versus McFarlane, communication of acceptance, Adam versus Lindsay. So this is 2, 3, 4, 1. A is the answer. And if you know that Moses versus McFarlane is on unjust enrichment, then you can just answer it, because 4 for the C is in only one option here. Otherwise, other options are 2 or 3 in number. Next 63. Suit under section 8 of Specific Relief Act is not maintainable against the owner of the article claimed against the person who has possession or control over the article. तो हो ही जाएगा. There would be a case in respect of article which compensation money not, that is for specific performance, not for fee. As per section 8, against the owner of the article can be claimed. A is the answer. Next 64. X is the holder of a bill payable to X or order X by simple delivery transfer the bill without endorsing it to Y. In this case, Y is only a assignee of a choice of action till the bill subject to all defects. A is the answer. And where it is mentioned, kindly comment in the comment section. You should participate because it will be helpful for you. Next 65. The mortgagor may deposit into the court the money due on mortgage, but after the principal money has become due and before the suit of redemption is barred. If on fulfillment of both the condition mentioned above, both. C is the answer. Where it is mentioned in section 83 of Transfer of Property Act. Next 66. To deal with cases where same property on interest therein is transferred to different person in such a manner that use of enjoyment by one transferee is against the interest of the other, the rule of election applied. If rule of priority is applied, C is the answer. Next 67, identify the incorrect statement in relation to doctrine of election. This rule will apply only when two properties are transferred by same deed. It is correct. The owner of property should get a direct benefit from the transfer. Yes. The person professing to transfer should have the right to transfer. No, it is not necessary. So incorrect is C. C is the answer. Limitation is 1 year. This is correct. And section 35 TPA talks about doctrine of election. Next 68, which of the following is not an actionable claim? So right to dower of a Muslim woman is not an actionable claim. Yes, it is not. And then you can see claim for mean profits, decree of court. They are not actionable claims. Other three are actionable claim. A is the answer. Section 130 of TPA talks about how it can be transferred. Next 69, a person who has been ousted by a trespasser for the possession of immovable property to which he has merely possessory title files a suit for recovery of possession after 6 months from the date of dispossession. As per section 6 of SRA, he can file a suit for recovery of possession only within 6 months from dispossession. After that, he can bring it on the title. So he has possessory title. So they are not mentioning it under which article or section you can just file the case. But for title, then the time period is 12 years. A suit can be maintainable. It can maintain a suit for possession. D is the answer. But on the basis of title, they should have mentioned it. Otherwise, it is confusing. He can file possession with explaining the delay for sufficient cause. But he can file an application under orders 7 rule 6, not under limitation act. That would be a problem over here as well. Next is 70. Which of the following is incorrect statement? In civil cases, character evidence is admissible unless the character of a party is fact and issue. It is correct. Section 52. In criminal case, the fact of person accused of a good character is irrelevant. No, it is relevant. 53. A previous conviction is relevant as evidence of bad character in criminal cases. Yes. 54. In criminal proceedings, evidence of bad character is admissible when evidence of good character has been given. Yes, it is correct. This is explanation 2. This is 54. So which is incorrect? B. B is the answer. It's talking about Evidence Act. Next 71. Hearsay evidence is generally inadmissible. However, in certain cases, it is admissible. Now they are asking for the exception to the hearsay evidence. Registry, admission, confession, declaration, all of the above. D is the answer. Next is 72. Due execution of a document more than 30 years old coming from proper custody is a presumption of fact, because they are presuming the facts that it is properly executed. Which section is this? Section 90 of Evidence Act. Next 73. Which of the following is not amongst the category of person whose statement becomes relevant fact as per 32 of Evidence Act? A person who is dead cannot be found. A person who is in judicial custody while giving a statement later died. It is as good as dead. So none of the above is the answer. D is the answer. Next 74. B has written letters to address to A. Likewise, A wrote letters to B. C is a B's clerk whose duty was to examine and file B's correspondence. D is B's broker to whom B habitually submit the letters purporting to written by A for the purpose of advising him thereon. Choose the correct option. Opinion of B, C and D is on the question whether the letter is handwriting of A are relevant. Yes, they are relevant. They are irrelevant. No. Only B. No, wrong. So A is the answer because they are acquainted with handwriting of the A. So they can give their expert opinion. Next 75 under section 9 of Indian Evidence Act, which of the following identification is relevant? Identification accused, deceased, victim body, articles, vehicles, all of the above. D is the answer. It's called test identification parade. Next 76. Which among the following plea taken by the counsel for the accused binds the accused? Plea of guilty. B is the answer. Dispensing proof or dispense witness, they are not bound that. B is the answer. Next is 77. A, B, C, D and E designed a plan to abduct and sexually assault G. The 5 accused abducted G and took her to a isolated building while B and C held her on the ground. A, D and E raped her. Suddenly E grabbed G's neck and strangulated her to death. Which of the following is correct? A, B, C and D, E are guilty of offense of gang rape and murder. No, only E would be guilty of murder. Why? Because their plan was to abduct and sexually assault, not for murdering that. So all are liable for gang rape, and E alone would be guilty for the offense of murder, as it is an act done not in the furtherance of common intention. So 3 statement is correct. C is the answer. Next 78. A is invited by B for a cup of tea. While B is in kitchen preparing tea, A finds a golden ring on the table. He picks it up and places it somewhere in the room with intention dishonestly taking it away sometime later. A commits theft. D is the answer, and this is illustration H of section 378 IPC. Next 79. Bolam's test applies to medical negligence. B is the answer. It is a Bolam versus Frieren Hospital Management Committee. This is the full name of the case. Next 80. A finds a valuable ring on the road. He immediately sells it without attempting to discover the owner. He has committed dishonest misappropriation as per section 403. C is the answer. This is illustration of that section. Next 81. 2 known person and 3 unidentified person waylaid Ramu and decamped him with his jewel. The following is correct. Now you see there are 5 in total number, 2 identified and 2 unidentified. So 2 known person can be committed for dacoity. Yes, they can be. 2 number only committed for robbery. No. Only fact need to be established that they are 5 person. If the fact is established, then even if single person can be committed for dacoity. It is provided in dacoity is in 391, robbery 390. Answer is A. Next 82. A judicial magistrate court tried an accused for committing an offence under 228 IPC. At the same time, the accused was also tried by the High Court under the contempt of court for the same occurrence. Now see, this is a criminal activity and this is a contempt of court. Both can go simultaneously. D is the answer. This is 83. A fresh suit on the same cause of action is not barred when the plaintiff is Order 7, Rule 11. Yes, it is mentioned in Rule 13 that we can file a fresh. Order 9, Rule 2, 3. Yes, it is mentioned in Rule 4 of Order 9 that they can file suit afresh. So all of the above are correct. D is the answer. Next is 84. Where an order for compensation against the plaintiff is passed under Section 95 CPC, a suit for compensation in respect of such arrest and attachment can also be filed. Yes. No, he cannot file. Suit for compensation in respect of such arrest and injunction attachment is barred. D is the answer. And it is mentioned in subsection 2 of Section 95. Next 85. In a suit for partition, defendant claims right under a will and files a petition seeking stay of the suit under Section 10 CPC till the probate proceedings filed by him before High Court is disposed of. Choose the most appropriate. Petition is maintainable. No, it is not maintainable because that suit is for probate and these claims are right under a will. These are 2 different suits. So C would be the answer, not maintainable. Next 86. A defendant has filed his written statement making an admission. Subsequently, he seeks the indulgence of the court to amend the written statement for deleting the admission made earlier under Order 6, Rule 17. Defendant cannot be permitted to amend the written statement. Why? How? Because it will take away the right of the other party and this cannot be permitted. A is the answer. And that would be a contradictory statement which was given earlier. So there are so many points on which it can be refused. Amendment of pleading is under Order 6 and Rule 17. Next 87. Statement 1 is in case an ad interim injunction was not granted and notice to the respondent was ordered, the plaintiff can file appeal against same. Yes, in case an interim was granted and notice to the respondent was ordered, the defendant can file appeal against the same. Yes, what is the point of asking this? The same thing, and they're asking that when refused and when granted. A is the answer, both are correct. Next is 88. A stepmother can claim maintenance under Section 125 from her stepson, provided she is childless and widow. Yes, it is correct. Then she is childless and husband is incapable of supporting and maintaining her, provided her husband is capable of supporting. No, this is wrong. So A and B both are true. D is the answer. Next 89, under section 53 CRPC, which of the following statement is correct? Statement: only at the instance of police officer not below the rank of sub-inspector medical examination of the accused can be ordered. Yes, it is correct. Victim de facto complainant can also seek medical examination of the accused through an order of the court. Yes, it is correct. Court can suo motu order medical. Yes, it is correct. All are correct. A is the answer. Next is 90, which in the following is not true with respect to the information to police? Statement 1 is the report must be given by a person who has personal knowledge of the incident. No, it is not required. If say somebody has given information to him, it could be hearsay information, but if it is regarding a cognizable offense, then he can file an FIR. The informant need not be an eyewitness in the incident. Yet it's correct. FIR can be used to corroborate and contradict the maker. Yes, it is correct. So 2 and 3 are correct. Not true is asked here. So statement 1 is the answer. Next is 91. Which of the following circumstances attract 195(1)(b)(2) of CRPC? That is prosecution for contempt of lawful authority of public servant. So plaintiff produced a forged will and suit claimed was negatived. No, not in this. Defendant while pursuing court record made alteration in promissory note. Yes, it is correct because it is for contempt of public authority. Next 3. Petitioner filed forged rent receipt. No, it is not. When some court record has been tampered, that is contempt of lawful authority. C is the answer, second situation only. Next 92. Who among the following are persons aggrieved are entitled to prosecute for offence punishable under chapter 21 of IPC? Now you understand what is chapter 21 under IPC. That is defamation. Defamation alleging unchastity of a wife suspended from service on the said allegation. Her husband has filed a complaint as aggrieved person. No, because he was suspended from service, so she can file. Newspaper article published against husband's laches in official work. Again, official work only he can file. Where defamation is made against the office bearer association, again office, then whoever in the office only he can file. So none of the person mentioned aggrieved in the illustrations. B is the answer. Next 93. Illustration 1. In a case and counter, one case comes to the magistrate by way of a private complaint while the other case goes to the police. The magistrate was informed that counter case is pending investigation before the police. Okay. In case and counter, one case comes to the magistrate by way of complaint. Complaint involves offence triable by court of session while the other case goes to the police. The magistrate was informed that counter case is pending for investigation. Labour Office files private complaint before judicial magistrate. In which of the following session inquiry under section 202 can be ordered by the judicial magistrate? In one only. B is the answer. B is the answer. Next 94. After preliminary assessment of a juvenile in conflict with law, Juvenile Justice Board referred the case to Children Court for trying a heinous offence. The Children Court remanded the case back to Juvenile Justice Board for proceeding against the juvenile. Now statement 1. The Children Court cannot remand back the case if it can remand, shunting the juvenile back and forth between forums, violating the right of the juvenile. Children Court cannot remand the back. So in these two statements, only one can be correct because both are contradictory. So 1 is correct, then 3 is correct. A is the answer. Next 95. An accused was tried for triple murder and sentenced for life imprisonment. The conviction was confirmed by Supreme Court. After serving substantial years in the prison, the convict filed petition before Judicial Magistrate Court raising the plea of juvenility. Which of the following is correct? The petition before is maintainable. Yes, it is maintainable. A is the answer. Next is 96. Definition of intermediary includes cyber cafe, shopping, online platform, network service provider. All of the above. D is the answer. They are asking from IT Act now. They should have mentioned the IT Act. Next 97. The IT Act makes the following act punishable by life imprisonment: hacking, data theft, cheating by personation. None of the above. D is the answer. Next is 98, which is correct. Statement 1. Digital signature and electronic signature are the same. Yes, it is correct. DS is technology neutral. No, wrong. This is wrong. So 1 is correct, 2 is incorrect. C is the answer. Next 99, Joseph, a watchman of a factory, was allowed to occupy the factory quarters, and from his salary a portion was deducted as charge of the quarter. It happens. The fee deducted would come within the definition of rent. Yes, it can be, unless payment is specific towards the rent premises. The payment, no, it is rent only. It is only premises occupation, no receipt. A is the answer. Next is 100. If an investment increase from 800 to 1100, what is the percentage of increase? 37.5. A is the answer. So friends, here we have discussed the preliminary exam paper of Tamil Nadu Judiciary 2019. So if you have find any problem in that, or you want to suggest anything, you want to make any query, just go in comment section and comment over there. We always appreciate your comments and valuable feedback. And friends, if you like the efforts, kindly give a super thanks. Minimum starts for 20. And अगर आपको वीडियो अच्छी लगी इसको जरूर लाइक कीजिएगा. And don't forget to subscribe our channel. And while subscribing, don't forget to press the bell icon so that you can get the notification of our upcoming videos. So friends, thank you. Thanks very much for watching this video. Thank you.